I'm a criminal defense lawyer in Hartford. I believe, however, that my comments apply throughout the state. It's my concern that the money bail system, as it operates in Connecticut, is a disaster. The failures of the money bail system must be addressed within the next few years. The system is long overdue for change. Racial disparity in jails and prisons is due in significant measure to economic disparity among racial groups in Connecticut. Poverty limits the ability of minority defendants to make it. My caseload consists exclusively of special public defender representation in state courts and court appointments in the federal courts. By definition, my clients are indigent. They cannot afford a private lawyer. They can rarely afford bail. Setting bail at a particular level for all defendants charged with a given crime may sound fair. However, it serves to detain defendants who have little money available. On paper, Connecticut's bail system looks flexible. However, reading the practice book, Chapter 38 refers to pretrial release, gives no sense whatsoever of the way the system actually operates. Several years ago, a judge of the Superior Court here in Hartford set bail for one of my clients at $300,000. That is a substantial sum. But a person with property may be able to post real estate, cash in an insurance policy, or perhaps take a loan from a credit union. My client had the nerve to tell the judge, I'm just an ordinary guy from the north end of Hartford. There is no way my family can put up $300,000. My client had been found indigent and eligible for court-appointed lawyer. No one ever questioned that finding. He was just playing out of luck, the way lots of other defendants are, because the court system does not take into consideration his financial situation. Just one other example. A couple of years ago, I had a client who was 16. He was being raised by a drug-addicted single mother. She'd been evicted from her apartment a few days before the court hearing. He'd never met his father. The charge was attempted larceny. It was my client's first charge in adult court. We explained to the judge that the $100,000 bond he proposed would effectively detain the child without bail. It did. After several months, the client gave up fighting the legal aspects of his case. He pled guilty just to get rid of the case. He needlessly obtained a felony criminal record, which he could likely have avoided by making a reasonable bail, had one been set, or had reasonable conditions been set. This young man, more than any other client I've ever had, sincerely wanted to get out of jail to go to school. The Hartford Public School System was willing to take him back. He asked the counselors at Manson Youth Institution whether he'd be permitted to attend both the morning and afternoon educational sessions there, even though they were the same, covering the same material, because he so much wanted to be exposed to teachers, be able to have access to education. Instead, he copped out. Rather than being able to be released on some bond, to live with relatives who showed up in court explaining that they were prepared to take him into their homes. The injustices of the bail system really deserve the attention of this commission. The bail system must be reformed. There's got to be a better way of dealing with individuals who are presumed to be innocent. Thank you.
David Silka.